Hi, this is Steve Carlson. I'm at the Minnesota State Capitol in the expected final week of the session. Your legislators and their staff are all over, making critical decisions for Minnesota's future. It's May, and I'm locked in election law litigation with the DFL, and the Republicans are an interested bystander. We're deciding whether these two national parties are going to be allowed to go back to their pure duopoly they enjoyed until the independent voters associated behind Ross Perot in 1992. And today's, or maybe yesterday's, Independence Party was born. And I just had to file a petition for rehearing and a motion to correct a clerical error and for review, because Minnesota courts are taking over the election process in Minnesota. They're not allowed to do this. Everyone agrees, because the judges in this contest, which was timely filed just after the invalid election of Al Franken, filed December 2nd. The sole judges are the U.S. Senate, and they have never weighed in on this election because Minnesota judges, who are elected, have pulled a few strings in violation of the U.S. Constitution to keep it from them. That is what this action is about, to challenge a cynical toss by Lori Gildea, the Republican Chief Justice of the Minnesota Supreme Court. Ultimately, it is increasingly clear that the United States Supreme Court is going to have to look at this. There's still a petition before the Minnesota Supreme Court. That's an election petition. But if Gildea were to succeed in once again blocking this contest, she will poison that too. This submission I'm reading from here isn't all about laws and motions, though. It's about democracy. It's about the 2016 presidential race. I believe I can carry 5% or more in the state, and I'm running against Clinton, against Sanders, Bush, Cruz, Walker, Fiorina, all of them. But first, we've got to save our federal democracy here in Minnesota. And I understand these anti-independent shenanigans of the two national parties, Democrats and Republicans, goes on all around the country. So here goes. To cut to the chase, the Chief Justice has just tossed an appeal from a motion to void the proceedings below because they enabled Al Franken, their enablers, to seize an illegal election certificate December 19th, while this contest was still pending, not determined by a proper court, in violation of Minnesota election law. Petition for rehearing and combined motion to correct clerical mistakes and motion for review. Memorandum of law, notice. Please take notice that contestant appellee Stephen W. Carlson, Steve Carlson, brings before the court this petition and motion to reinstate and remand the appeal dismissed by Chief Justice Lori Gildea in an order of April 30th. That should actually say, that will have to be corrected. Pursuant to Minnesota Rules of General Practice, Rule 377, procedure on a motion to correct clerical mistakes. Motion for review or combined motion. Minnesota Appellate Rules, Rule 140, petition for rehearing. Minnesota Statutes 209.12, Congressional Office Contest Statute, and Minnesota Rules of Civil Procedure 6.05, additional time after service, and Minnesota Rules of Civil Procedure 6.02, enlargement, and under all Minnesota civil rules not inconsistent or conflicting with Minnesota Statutes 209.10, Subdivision 4, and Chapter 209 General, or Article 1, Section 4 of the United States Constitution. Petitioner and movement and contestant Stephen W. Carlson petitions this court pursuant to Minnesota Rules of Appellate Procedure 140 and moves pursuant to Minnesota Rules of General Practice Rule 377 that the court reinstate my appeal and remand this contest appeal back to a neutral panel for briefing and oral argument on the grounds that, based on the facts in my accompanying affidavit and on the law and arguments in my memorandum below, it is timely, and because it must be corrected because of clerical error and lack of notice provided to me of the court's actions and requirements. Facts. On April 9th, 2015, petitioner and movement, I will use this first person because of the multiple titles for clarity, Steve Carlson, filing under the provisions of the Minnesota Rules of Appellate Procedure, took appeal from the order of a 3-judge panel appointed by the court in court file number 62-CV-14-7915, Ramsey District Court, denying on March 27, 2015, my post-judgment motions, but in no way deciding the case or the contest. Because the panel appointed by this Supreme Court Chief Justice had relied on temporary urgency to deny and refuse to void the contest proceeding, and footnote 1. It is a plain fact that the proceedings of the panel in the contest are null and void because of the facts and laws set forth in the instant appeal, but also because during this proceeding they, being Mark Ritchie as a party and respondent for the state, and Governor Mark Dayton, issued the election certificate in violation of Minnesota Statutes 204C.40 subdivision 2, which bars the issuance when the contest is still pending, not finally judicially determined by a court of proper jurisdiction. The contest was still pending when the certificate of election was issued, December 19, 2014. Therefore, this court and its panel have given material aid to Franken, Dayton, and Ritchie to abrogate our solemn election law, and thus violated the U.S. Constitution, Article 1, Section 4, which states that the Minnesota legislature and this court and all Minnesota courts must strictly follow and enforce the laws prescribed for electing federal officials, members of Congress, in the time, place, and manner stated herein. See Smiley versus Holm and Rodebush versus Hartke. Those are both United States Supreme Court cases that explain this duty. So that was a small footnote. As if the Minnesota courts had no other purpose than to count Franken's votes and send him on his way in a valid election or no valid election. And another footnote, as presiding Judge Vandenorth pronounced to begin the panel's proceedings December 18, 2014, quote, "Let's get this railroad moving," unquote. Now, I chose to cite the most expedited statute of limitations in the state legislative race provision, Minnesota Statutes 209.10 subdivision 4, since that statute had been applied by the panel and this court as controlling appeals from orders of the panel deciding, quote unquote, the election contest. This, of course, did not decide it. See affidavit. But the instant appeal is also timely under Rule 104 of the Minnesota Rules of Appellate Procedure, and its 60-day limit for appeal because the appeal is admitted to have been filed under the appellate rules on April 9, 2015, 13 days after the entry of the order appealed from March 27, 2015. There is no issue of any filing of appeal necessary to give jurisdiction to this court, since this is a court that had jurisdiction and did in fact choose and empower the three-judge panel. Minnesota Statutes 209.045 provides that, quote, "the case must be heard and determined," I underline and italicize that, "in Ramsey County by three judges assigned by the Chief Justice of the Supreme Court," unquote. This underscores the duty of this court and its panel to hear the full scope of Minnesota Statutes 209.12 and to determine the contest. That was not done when the DFL officials issued Franken's certificate. 209.10 subdivision 4, as this court said in Soika, does not stand alone, deciding the Minnesota Rule of Civil Procedure 6.05 issue, that's the 3-day cushion for when you receive the notice by mail. And this was in tax court cases. But it also stands with Minnesota Rules of Appellate Procedure 104.01, time for filing and service, which provides a 60-day appeal period. And it stands with Minnesota Rules of Civil Procedure 6.05 as interpreted by this court in Soika inter alia, and not as insisted upon by Chief Justice Gildea. It also stands with Minnesota Rules of Appellate Procedure Rule 126.01, which directly cites the applicability of 6.05 to appeals. Chief Justice Lori Gildea responded to this appeal by threatening to dismiss it for being untimely because it was filed by U.S. mail and thus effectively filed April 9, 2015, 13 days after the order appealed. She entered this order April 20th, 2015, but it was not mailed to me as I have arranged with this court. And footnote 3, see affidavit. Instead, I accidentally learned of this order in expectation for an informal memorandum to be filed April 24th, 2015 on April 30th, 2015. See affidavit. I talked to the clerk's office May 5th to find out how this happened. Also affidavit. Determined to file this petition and motion to seek to remedy this unjust and unconstitutional situation. Chief Justice Gildea cites Minnesota Statutes 20910 Subdivision 4's appeals provision and holds erroneously that if this was an order of the panel which decides the contest, the 3-day extension for the time for expedited filing of the time would not be allowed by Minnesota Rules of Civil Procedure 6.05, because for some reason that is not at all clear, 6.05 does not apply to election contests, she says. She cites no authority for this except a string of tax court cases. And Soika was decided against her interpretation there, where she wrote the dissent. And it is even less applicable here, where she is sitting and acting as a judge in a U.S. Senate contest, which is not allowed by Article 1, Section 5, U.S. Constitution. See Morgan versus Freeman, 801 Fed 2nd, 445, D.C. Circuit, 1986. Chief Justice Gildea also took the opportunity in her April 20th, 2015 order to restate her false and erroneous position that the Congressional Office Election Contest Provision 20912 statutorily limits contests to just who got the most votes. She unlawfully equates entitlement to receive the certificate with the final official authority to issue the certificate, which under our law only accrues when all contests in the race are finally determined, and the contest has still not been decided. Additionally, the April 20th, 2015 order seriously misrepresents the posture of this entire case. Apparently, because this court was excited to bury this contest from public view, we took some action January 15th, 2015. Not just on the appeal I did bring, December 26, 2015, because of the fiasco and railroad at the panel contest proceedings, but as you style it, the entire contest. And footnote, Gildea finds, quote, on January 15, 2015, the court dismissed this election contest appeal due to uncorrected deficiencies in the filings of appellant Steve Carlson. By that time, an election certificate had been issued to the candidate for U.S. Senator from Minnesota with the highest vote count in the general election, contestee Senator Al Franken. See Minnesota Statutes 204C.40, Subdivision 2, 2014, permitting an election certificate to be issued when an election contest has been finally determined. See also Minnesota Statutes 209.12, 2014. Quote, the only question to be decided by the court in an election contest is, quote, which party to the contest received the highest number of votes legally cast at the election and is therefore entitled to receive the certificate of election. This order is highly objectionable and contains a deliberate falsification by the state's highest court of Minnesota election law. And again, Chief Justice Gildea seems intent on legalizing fraud and corruption by Governor Dayton, Al Franken, and Secretary Ritchie, because she pretends that the election certification was legally issued. She dishonestly omits this very material fact, that the date of issue was December 19, 2014. She suggests, even though she does not say it, that the certificate was legally issued under Minnesota Statutes 204C.40 Subdivision 2, because she deliberately allows as an inference that it was authorized to be issued, because at the time of its issuance, the contest had been supposedly finally determined. If this deception is truly intended, then this deliberate lying by an elected Supreme Court Chief Justice simply must come to an end now. Correct the lie, and do not continue to lie in violation of our U.S. Constitution, regardless that she's a Republican. I won the statewide primary to become the nominee for the U.S. Senate of the Minnesota Independence Party, which is a competitor to Chief Justice Gildea and her Republican Party. And footnote 6, she would need to seek the endorsement of the GOP party to run. In the 2014 general election for U.S. Senator, that I competed with her party. And that's a statewide office where a 5% portion of the statewide vote was needed to allow the party to continue in its major political party status. Based on what is alleged to be an invalid election, I filed an election contest pursuant to the statute of limitations prescribed by the Minnesota legislature in the Congressional Election Code, under the broad grant of authority that the Minnesota legislature, by the framers of the United States Constitution in Article 1, Section 4, were given. Now, the federal courts, notably Morgan Supra, has at this time, and at this time also the contestees, Franken and Simon, who was substituted for the former Secretary of State Mark Ritchie, agree that Article 1, Section 5 U.S. Constitution makes the U.S. Senate the sole judges, expressly excluding this court from judging any U.S. Senate or U.S. House election contest, and textually committing the matter to the U.S. Senate. And now, before Al Franken appeared in Washington January 6, 2015, with his illegal election certificate, which Chief Justice Gildea has just shamelessly pronounced fully authorized and legal, Al and his legal team suggested that despite the U.S. Senate being the sole judge of this contest, of which he unbelievably was a judge as an incumbent senator, notwithstanding that this court and the panel could and should exercise all of these supposed powers to judge this case, including Judge Franken's motion pursuant to Rule 12 of Minnesota Rules of Civil Procedure to dismiss the whole contest. But isn't dismissal something that judges do? But after this scam, and this court's willing participation in violation of our nation's Constitution, Franken now admits that you, the Minnesota Supreme Court, are not allowed to sit as judges of this congressional contest. You continue to have a solemn duty, of course, and an oath to ensure that the CCEC is followed. That's the Comprehensive Congressional Elections Code, including the U.S. Constitution. Were Justice Gildea's order to finally determine this contest, barring actions to void the entire proceeding which might be available, this record would proceed to the U.S. Supreme Court and continue to be informally reported to the U.S. Senate and the American people. This is an embarrassment for Minnesota. And yet, this court persists in acting as judges, and have for all these years shielded two DFL candidates, Betty McCollum in CD4 and Al Franken in the U.S. Senate, from the contest statute 209.12 at all. I was also not even served with the notice that the appeal had been filed in this court. I walked up to the clerk's office and personally asked whether it had been filed, and was told probably on the 20th. I was working on the petition I filed April 23rd, that it had just been filed. Now, more facts. The issuance of certificate of election to Al Franken illegally by Governor Dayton and Secretary Ritchie December 19, 2014, while this contest was still pending at the panel you appointed. As a result of the wrongful actions of the panel and of Senator Franken as a judge in his own contest, and of DFL state officials who sought to destroy the remedy of contest in order to protect their partisan in the U.S. Senate, Dayton and Ritchie, in the shadows of the illegal actions at the panel, and without my knowledge, wrongfully issued a fake election certificate because it was full of falsehoods and issued in violation of the law on December 19, 2014, before I was even notified that the panel had acted December 18th to truncate and disfigure the constitutionally required statutory contest which was filed. Honorable Chief Justice Lori Gildea, however, refuses to even note this event and its date in her order because it would prove my case and show the lawlessness of her court. And so she establishes a false record, which needs to be corrected. Instead, she says, quote, on January 15, 2015, the court dismissed this election contest appeal due to uncorrected deficiencies in the filings of appellant Steve Carlson. And footnote, the deficiency was that I never appealed the whole contest, and so it is false to say any appeal of the contest was dismissed by this court. Better to say I was deprived of my right to appeal. I did not want to appeal that part, which had not yet been lawfully decided. And all that I tried to do December 26, 2014, in plenty of time to halt the seating of Franken January 6, 2015, was to put in front of this court, by an appeal and petition for mandamus, the illegal tactics of Franken and Ritchie, and the need for the panel to proceed according to 209-12, not some harebrained preference of the incumbent, Senator Al Franken. Justice Deason, albeit way too late, did in fact note that even though I didn't know the certificate was already signed, sealed, and delivered, the legality of issuing the election certificate needed to be briefed in this court. But I didn't see it. I was moving, see Affidavit 9. I did not have internet access, and it was already too late when this court issued the order January 2nd, 2015, to stop the January 6th seating. Franken cheated and then ran out the clock. Further, this court does not have the power to judge the contest. Instead, there is an expectation that the Minnesota courts need to just follow the law, not engage in extensive legal manipulation and avoidance of your duties. I should not have to win an argument in this court for you if you were aware of the issuance December 19th to rescind immediately, since you knew the time for appeal or resolution for appeal had not run. I could not debate this with you at the time, but in the motions filed with the panel and disposed of March 27th and appealed here, that definitely needs to be briefed and determined according to the law. Chief Justice Gildea's transparent attempt to suggest its authorization by Minnesota Statutes 204C.40 subdivision 2, giving cover to the corrupt action of the governor and other DFL officials, continues the travesty she has presided over. I have described the flaws of this falsification of the congressional elections contest in a note. I do not agree my motions decided March 27th were post-appeal. Now here's the argument. I'm just going to give the summary of the argument in this short video. Number one, contest appeal should not be stopped on the grounds stated in the April 30th order. And footnote 9, again, the language of the statute is plain and clear, she says. The right to appeal expires no later than 10 days after the panel's order. See O'Loughlin versus Otis, 276 Northwest, 2nd, 38, Minnesota Supreme Court, 1979, where they said, we have consistently held that where the legislature has set strict procedural requirements and time limitations in order to get election contests expeditiously resolved, we would adhere to a rule of strict compliance with the statutes, unquote. And she goes on, Carlson's appeal was filed after the appeal period in this matter expired. He has offered no reason to believe that his appeal is timely, nor has he provided any reason to excuse his late filing, unquote. And basically, the grounds are timeliness generally. Now, this includes the fact of a clerical error by the court choosing to email the order to me just because I had given my email address to the court for an expedited motion in October during the election, which gives rise to review under Minnesota Rules of General Practice, Rule 377. And this motion is well within the 20-day time for seeking correction after discovering the clerical mistake, which I just discovered May 5th, 2015. Further, too, the court should reverse or at least withhold judgment on the following issue regarding this contest. This is Franken 2, as opposed to the 2009 contest, Franken 1, that's Franken versus Pawlenty, 2009, in which the first ruling was made and is applied as well in the order. Whether congressional office election contests under 209-12 are statutorily limited to who received the highest number of votes legally cast and is therefore entitled to receive the certificate of election. I note strongly at the outset that even this Minnesota Supreme Court could see in Franken 1 that this ultimate issue is not allowed by the statute to be decided by the court or any Minnesota court, and as Morgan Supra says, no court, no judge is authorized to decide this issue, solely the Senate or the House. Finally, 3, the false and ultra vires finding or suggestion by Chief Justice Gildea that the issuance of the election certificate to Al Franken, December 19, 2014, and she should be forced to admit the date of this wrongful act as a material fact, and may not appear to give the blessing of the court to this kind of shenanigans by using the deceitful phrase, quote, before January 15, 2015, as opposed to December 19. to describe when the certificate was issued, supposedly with authorization under 204C.40 subdivision 2 for being finally determined at the time, which of course it was not. This is a deliberate attempt to violate the law and is malum in se as well as malum prohibitum. That means it's wrong in itself, not just codified into the law. It's really wrong, and to hold herself above the law. And so I'm just going to complete this video at this time, and I will go through the arguments. I will also be going through each of the grounds and showing how each one is regulated by the U.S. Senate, not the Supreme Court, not the state legislatures, and regulated by the U.S. House of Representatives. The United States House of Representatives, the United States Constitution, that's what these local politicians are violating here. And this is very important because independent voters need, under the Constitution as decided by the U.S. Supreme Court, to have an equal treatment, not have burdens fall on them unequally that are imposed on them by Democrats and Republicans in order to destroy their constitutional associational rights under the First Amendment. This is Steve Carlson, and I approve this message.